Okay, hello. This is a bit of a unique experience for me. Usually when I give a presentation, it is to people. So if I pause or look confused for a moment, it's probably usually at that point where I would ask a question of the people in the room or something like that. This presentation is called Criminal Law Basics. I've been arrested. What happens now? You might call it the oh shoot presentation. What happens to me? This is a presentation entirely based on Cincinnati and Hamilton County. Criminal law works differently, not dramatically, but in certain ways, in procedurally and how they do things in different counties. This is an entirely Cincinnati, Hamilton County based concept. I'm Erik Laursen. I've been a practicing attorney for 12 years. I practice in the area of criminal defense. I'm a founding member of the law firm of Laursen and Lucas Attorneys at Law. My partner, again, Rana Lucas and I, we practice in criminal defense, do quite a bit of criminal defense, both for indigent defense clients, people who we're appointed to through the county, as well as private defense clients, people who are paying us privately to defend them in criminal matters. So, what's the very first thing any criminal defense lawyer is going to tell you? If you are stopped by police, if you are questioned by police, if police want to talk to you for any reason, you should exercise your Fifth Amendment right to remain silent. You've heard it before. You've heard what's called the Miranda warnings, and they include a sentence: anything you say can and will be used against you in a court of law. And truth be told, that's really not just a phrase from a TV show. What you say will be used against you, no matter what you think it is or how helpful you think it is. And here's the fact of the matter. If you're a person who's in trouble and you've never been in trouble before, you're probably a little bit flabbergasted. You're confused, you're scared, you're concerned, and you have police officers asking you questions. And we've been told since we were children that police are there to help us, that they're there to assist us and protect us and all of that. And the unfortunate truth is that when a police officer suspects you in a crime, you need to exercise your constitutional rights. You're not being rude. You're not doing anything wrong. You're doing the right thing. You are protecting yourself. You have to put that person first. And here's the thing. Everybody wants to be helpful. Everybody feels compelled to try to explain themselves. But I can't emphasize enough that anything you say will be used against you. A good example of this is my sister. My sister is a wonderful nerd, for lack of a better word. She is a scientist. She works for the government. She's never been in trouble a day of her life. She got a near perfect score on her SAT. All of those wonderful things. She is the kind of person who would spill her guts to the police. And I've told her over and over and over again, if something like this were to occur to you, you don't talk. It's not being rude. I'm not saying don't be polite. I'm not saying run away from the police. You don't want to do that. That's a whole new charge. What you want to do is ensure that you are not giving them information that could be used against you. And the best way to do that is say, I'm exercising my right to remain silent. I'd like to speak to a lawyer. Period. All right. Now, you may be asking yourself, what is a crime? A crime actually is something very specific. It's an action that a statute, that's a law, prescribes you from doing. Meaning, in order for a crime to have been committed, a statute has to say you can't do that. So there's drug crimes, violent crimes, sex crimes, and different levels of what's considered criminal activity. A felony, those are the so-called worst kinds of crimes. Felonies carry a possibility of prison, and they are categorized from a first-degree felony through a fifth-degree felony. What's that mean, Erik? Okay. A first-degree felony, those are the real serious ones. Homicides, crimes of extreme violence, burglaries and thefts where you break in and it involves a gun or a weapon of some kind. Someone's life is endangered or harmed or ended. That's where we're in the first degree range. The fifth degree range generally are serious crimes, but oftentimes don't involve a victim. Felony drug abuse is a good example. Heroin and the opiate epidemic that our community and all communities are facing right now is a good example of what falls under sometimes a fourth or a fifth degree felony. But those two carry a possibility of prison. A fifth degree felony carries a possibility of up to 12 months in a state prison, and a fourth degree felony carries a possibility of up to 18 months in a state prison. So, God forbid you're someone who has an issue with opiates, realize it is indeed seriously, and it is taken very seriously by the courts. Now, that doesn't mean you're going to prison. Don't lose your mind and panic. A first degree offender of a drug charge will usually be brought in through drug court and helped through a treatment program. If drug court isn't an option or drug court doesn't work for whatever reason, most fourth and fifth degree felonies are probational offenses. You'll be put on a period of probation, usually about 3 years, where you will be expected to test clean for drugs, participate in drug counseling, do NA or any number of different programs that the probation department tells you have to do. Misdemeanors are considered lesser crimes, although sometimes some people would debate that. They too go from first degree down to what's called a minor misdemeanor. A first degree misdemeanor usually is pretty serious. It's an assault. Or a domestic violence often qualifies as a first degree misdemeanor. And I've been asked before, why does a drug crime that is victimless qualify as higher than a misdemeanor? And the best answer I can give is that's what the law says. The Ohio legislature writes the laws, and that's how they determined it plays. Domestic violence is treated very seriously in the Hamilton County courts, despite the fact that a first-time domestic violence charge is a misdemeanor, and is treated in a way where oftentimes it's not as probational, and there would be there. Now, there's a possibility of jail with a misdemeanor, up to 6 months in jail, 180 days. And this is where people go, well, what's the difference between prison and jail? Prison is a state institution, a Warren Correctional Institution, one of those things you may see from the highway with razor wire around it in a large space. The possibility of jail is the Hamilton County Justice Center when we're speaking here. It's right here in town, right here in the center of downtown, right across from the casino is probably the best way to think of it. And misdemeanor crimes are categorized, again, first degree through what's called a minor misdemeanor. A minor misdemeanor is kind of an interesting crime in that it's not really a crime, it's almost a ticket. It exists in kind of a netherworld between ticket and criminality. I would say the two most common minor misdemeanors are possession of marijuana, and I'm not talking a lot of marijuana, I'm talking you have a joint, you have a small baggie of marijuana. Those are called minor misdemeanors. They're commonly known as weed tickets. You do not face the possibility of jail for I'll call it a weed ticket. And another one would be what's called disorderly conduct. And there's two levels to disorderly conduct. There's fourth degree misdemeanor disorderly conduct, which would be where you'd face a possibility of 30 days in jail, and then minor misdemeanor disorderly conduct. Both of them, the wording of the language is acting turbulent and disturbing to people around you. Most of them can be best summed up as an example of somebody got drunk at a Bengals game and got really rowdy to the point where the police had to be called. That is really what happens with the disorderly conduct. So when we talk about crimes, they range from the most extreme to the most minor, but they are all things that you want to avoid. And God forbid, should you ever be charged with one, maybe at least have a little bit of an idea of what's going to happen to you. And that's why we're here. So let's look at, in order to keep things simple, let's think about a crime that ranges from the level of a first or second degree felony all the way down to the level of a minor misdemeanor, possession of a controlled substance. A first degree or a felony level, we talked about the 4s and the 5s. That's when you possess heroin, cocaine, something like that. It's higher up when there's trafficking involved, or a significant amount of drugs, or whatever it may be. It gets progressively worse what punishments you can face. It is, and we talked about what is a crime. It has to fit the elements. In this case, no person, that's you, shall knowingly obtain, don't get it, don't pick it up, don't buy it, don't do it, possess. And possess is a lot broader than you might think. It could be in your pocket, it could be in your car, it could be in your dresser drawer, it could be at your grandma's house, it could be any number of things like that. Or use a controlled substance, and I think we all know what use gets to. So as we discuss things, we're probably going to return to this as an example because it covers the whole gamut of situations. So you have been arrested by a police officer. You have respectfully and kindly denied their questions. You have identified yourself. In Ohio, it is a crime to not identify yourself to police if they have a reason to ask you. And if they are asking you about a drug crime or whatever it may be, that is something to keep in mind. You do have to tell them who you are. Beyond that, it would be my advice and any criminal defense attorney's advice in the courthouse: do not tell them what happened, why you were doing something, where you were, anything, because again, all of it will be used against you. It really will. So, you are arrested. You will be put in the back of a police car in handcuffs. It is not a comfortable place to sit. It's not a cushy seat. It's usually a hard plastic seat. And the cuffs are connected behind you, and you get a ride to the Hamilton County Justice Center. Just so you know, if let's say you're a family member watching, the door there, that's the door you walk in if you are going to go see someone immediately following their having been arrested. You'll be taken to the Justice Center, you'll be processed. It's not the most pleasant place to be. I would love to show some pictures inside the Justice Center beyond this particular security gate, but I'm not allowed to take a picture inside. Google it. There are pictures inside to show you that it is essentially a cinder block and concrete building with very little for you to do, but look at cinder block and concrete. Not a particularly pleasant place to be. I don't have a picture of the inside that I can use, but there are pictures out there from various news organizations and that kind of thing that you can see. Once you are arrested, let's say you're arrested at midnight, you will be processed in for what's called a Room A arraignment. Courtroom A is in the Justice Center, just past those doors that I showed you before. If you have ever watched local television news here in Cincinnati, you have seen Room A. Room A is where you see on television the person being walked out of a door by a very tall deputy, who, by the way, is a very nice man, and guides you over to an attorney. And for example, there I am on Channel 9 apparently doing an arraignment for someone who was important enough to make the news that particular day. Arraignment, this initial appearance is very limited in scope. It moves fast. Chances are you will be frustrated by it. You will be disappointed in it. It will be confusing and a little bit scary. That's okay. That's how everyone feels who goes through this. If you are arrested on a DUI and not released to go home, you will go through this. If you are picked up on a domestic violence, you will go through this. If you are charged with a felony, you will absolutely go through this. So know that your lawyer is there. They are doing their best to protect you, but it is straight out of the gate. And the only real question on that day is bond, which for you can be, am I going home today? What am I going to do? In Room A, the attorneys come back into holding, and they will talk to you about who you are, a little bit about what happened and all of that. I ask people for their name, their address, what they like to be called, where they work. Are they supposed to be at work later that day? Are they supposed to be at work right now? Where they went to school, Are they married? Do they have kids? Who can I talk to if you're not released immediately? Who is the right person to reach out to help guide them to be able to post bond or to do whatever? This is not the time to argue the merits of your case. It is not the time to say, I would like to talk to the judge. I know a lot of times you want to, and it goes back to what I said before. Only this time you're on the record. It's all getting recorded. And it's all right there in front of a judge, the prosecutor, court officials, all of that. Now, that doesn't mean that your attorney is not going to ask you questions about what happened, but there is simply no time on the point of that first arraignment to get all the details of your case. I promise you, whoever your attorney is will get all the details of your case. We'll go over everything with you. But right now, that is, are you going home today? And every attorney who represents you, their goal is to make it possible, if they can, for you to go home. Now, we've all seen it on TV, the $1 million bonds for murders, attempted murders, serious violent crimes, all that kind of thing. In that case, really the whole point is to, if there's something that needs to be put on the record immediately to help with the defense or to ensure that certain things happen, that all takes place. But on those crimes, generally, you're not going home. But for the most part, if you are charged with what people are most commonly charged with, a misdemeanor of some kind or a low-level drug crime, it won't be out of reach. It may be hard. It may be difficult, but it won't be out of reach. Several different kinds of bonds can be placed on people. The first, and what we're always shooting for and what we want, is what's called an own recognizance bond. You sign a piece of paper that says, I will return. I promise I will show up to court, and they let you go. That's good, and that's why I ask things and why other attorneys ask things about who you are. Because it is our goal at that point to convince the judge who's deciding, are you dangerous? Is there a risk that you're going to hurt somebody? Are you going to go back and hurt the person who said you did something wrong? Or are you someone with an education, a job, a place to be, and a reason to stay away from whatever got them in trouble in the first place? That's why those questions are asked. We're not trying to be nosy. That's what we're trying to help. Another kind of bond is a cash bond. Usually it's set at 10%. So, for example, you may let's give it a good example of what there might be a cash bond for: a domestic violence case. A domestic violence case, you will generally be asked to post some form of cash bond. Depending on the seriousness of the charges, it goes up. But that bond may be at 10%, and you'll also be told to stay away. In fact, you'll be ordered to stay away from whoever is accusing you that. And by stay away, it means stay away. No Facebook, no Twitter, no phone calls, no anything. If you see them in the grocery store, you take your cart, you push it aside, you leave. If they're walking down the street towards you, you cross the street and go the other direction. You cannot violate a stay away order because you'll end up back where you don't want to be, inside the jail. The final, for more serious cases, is a secured bond. If a judge says $10,000 secured, you need to come up with $10,000 to get out. Now, there are ways to assist with that, and families to assist with bail bondsmen and all that kind of thing. Frankly, dealing with bail bondsmen is a presentation unto itself. So, don't panic. You will have an attorney there. Whether you are a person who is an executive, well-employed, making a lot of money, or whether you are unemployed and have no money and in trouble, you will have an attorney there. When you are brought into the Justice Center and the jail, you're dealt with by sheriff's deputies who are processing you, fingerprinting you, doing all those things, and then you're put in that holding cell with everybody else. But you will have an attorney. The person up on the screen is named Earl. I'm about to blow it. I'm about to mess it up. Clarence Earl Gidgeon. And in 1963, he was charged with a felony and did not have an attorney. and argued himself all the way up to the United States Supreme Court, where in a 9-0 decision, they agreed with him that he had a right to an attorney whether or not he could afford one. So, the wholly owned attorney will be appointed to you. We can all thank Mr. Gidgeon there. How is that person assigned to you? The Office of the Hamilton County Public Defender has attorneys on staff who are there about 4 in the morning. They also have review people, administrative staff members who are there, who are going to be asking you questions about your job, your work, and figuring out whether or not you qualify for a public defender. If you qualify for a public defender, you will receive a public defender who will go with you throughout the entire process if you so desire, or someone like me, who is a private attorney who also takes public defender appointments. Because quite frankly, there's a volume that's significant enough of criminal cases where the public defender's office cannot handle everything, and therefore it's shopped out to contract attorneys. If you qualify for a public defender, your income level is such that you can't really afford an attorney without an extreme hardship, then you get that attorney. And a note here about public defenders. I have heard them denigrated left and right in my practice. I've heard them called fake attorneys, and people like me are real attorneys. I've heard them called public pretenders. Here's the truth about a public defender. They are the only kind of attorney who is only practicing in criminal law for people who can't afford it every day, every case. They went to the same law schools people like I did. They took the same exact bar exam other lawyers did. They are the real thing. And in this county, I'm really happy to say our public defender system has become more and more robust over the years. So don't be nice to your attorney. They really are attorneys. They really are good people, no matter what on that. If you do not qualify for an attorney to have one appointed to you, let's say you are that P&G executive or whatever, and you make a good living, and you do not qualify for a court-appointed attorney, even if you haven't managed to reach your attorney or a family member who's been scrambling, calling all over town, trying to find a lawyer for you, you will have an attorney that morning. You will have someone standing up next to you and arguing for bond and taking care of you that morning no matter what. They'll stand up and they'll say something along the lines of, Your Honor, I'm not submitting my designation on this case because this person does not qualify financially to receive a public defender, but I'm here to argue bond and to ensure that all of their rights are protected right now. And you will have that, and they will make sure you get through the process, at least through that morning. All right, again, 2 kinds of criminal charges. Let's start with felony. If you are charged with a felony, your case will go to the grand jury. After the bond argument is made and the very tall deputy steers you back into holding whether or not you receive an OR or any kind of cash bond. By the way, that deputy will probably whisper in your ear exactly how much you have to pay to get out. He's very helpful, he's very kind. He's tough as nails and very tall. Don't mess with him, but you'll get that information. Your case will be then turned over for a grand jury investigation. Now, I wish I could tell you a lot about grand juries. Grand juries themselves would be a topic for a whole other presentation, but for the fact they're secret. I've never been inside a grand jury. I worked for someone who sat on a grand jury, and he would not tell me anything. They are essentially a group of people who are presented a case by a prosecutor. It is just an overall, this is what the state intends to present, this is what we have at this point, and they ask themselves, is that sufficient to charge them with a felony? I'm not allowed in the grand jury room here in Hamilton County, and again, this is a Hamilton County-centric presentation. In Warren County, this is going to be different. Butler County, this is going to be different. Claremont County, this is going to be different. Generally, the grand jury will return its decision within 10 days. During that 10 days, if you are bonded out, you'll be talking to your lawyer. During that 10 days, if you're still in the Justice Center, your lawyer will probably see you within 24 or 48 hours to have a more reasoned conversation with you than what was possible sitting in a holding cell with 30 or 40 other people that morning. Now, don't get me wrong, it's not the best place to have a conversation inside the Justice Center. The picture that I can't show you, think of the Justice Center pods as pie-shaped. There's a door. Next to that is a control room where a sheriff's deputy sits and opens the big steel door automatically. Your lawyer comes in, gives them your name, and they sit down at a table that's mounted to the wall and chairs that are mounted to it. And beyond that, and that's called the Sally Port area. And beyond that, there's a glass and steel wall with 2 levels of holding cells on each floor. And you come in, they buzz you through, and you go down and you sit down across from your lawyer. Once it's time to have very serious, detailed conversations, you go to the library with your lawyer, you do different things, and it's set up so that there's privacy and all of that. But it's just not a comfortable place. If you can avoid it, don't do it. I know this is a bit of a tangent. I had a professor, actually an undergraduate law professor. He sounded a lot like Marvin the Martian. It was kind of distracting, but he left us with some words of advice. And at the end of the semester, I think the best advice he gave, and imagine this in a Marvin the Martian voice. I'm not going to do it, no matter. I'd just mess it up. But he said, if I leave you with nothing else, don't commit crime. And then he followed that up with, if you must commit crime, do it in Los Angeles. We are not there. We're here in Cincinnati, and you will, you're going to face a lot of challenges. In that 10 days, what happens? Well, the grand jury has different choices. They can indict you as charged. You're charged with felony cocaine possession. They can say, yes, there is probable cause for you to be charged with felony cocaine possession. It is then moving forward, you are formally charged with a felony, and you will have to defend against cocaine possession. They could amend the charges to misdemeanors. Sometimes this happens in situations where perhaps you had been charged with an aggravated or a felony level assault, and it comes back as a first-degree misdemeanor. That means that the grand jury thought you did something, but maybe not as bad as to make it a felony. Or you had a whole lot of marijuana on you, and they weighed it. And they weighed it in the field, and it was over 100 or 200 grams, and it put you into the land of a felony. And then formal lab results came back, and it was under 100 grams. Well, then it's different. It's a different situation. Or they can ignore it. A grand jury can ignore a felony charge, and it comes back formally. It's called a no bill. We refer to it as ignoring it here in Hamilton County. And that means the case is dismissed. That the grand jury at that point in time doesn't believe that the police and the prosecutor and the state have enough evidence to go forward. The hang up with that is they can bring it again. Jeopardy, double jeopardy, which is a topic for an entire class in itself, does not attach. You can be charged with the same thing again. Police can go back and gather more evidence and bring that charge again. And sometimes that is exactly what happens. The labs don't come back in time. As a result, there's no proof that there's actually drugs, or insufficient proof that there's actually drugs, and it gets ignored by the grand jury. Then the labs come back and it's represented. And that's just one example of a myriad of things that could happen. That said, if you get an ignore, it's good news. There's a chance that it will never rear its ugly head again. And at some point, you'll be able to expunge it, seal your record. Next steps. If the grand jury does come back with a felony, you will be arraigned again, this time in room 585 of the Hamilton County Courthouse in front of Magistrate Bachman. It's a felony arraignment because at this point you've formally been charged with a felony. Probable cause have been found to find a felony, and therefore you get an opportunity to say not guilty and to ask for an amendment in bond. I'm going to be 100% honest here. Very, very, very rarely does Magistrate Bachman ever reduce a bond. And the magistrates who preceded him, very rarely did they reduce a bond that was set at the initial arraignment. And I think their thinking behind it is this: if you're here, what was suspected has at least been slightly confirmed by the grand jury. And therefore there's no reason to lower that bond. Which isn't to say you shouldn't try. Oftentimes there are extenuating circumstances. I once represented a woman who had drug addiction issues, but who also had an aggressive cancer and needed to be out to be treated. And her bond was made, it was basically called an intensive own recognizance. She had to check in, she had to report, she had to verify that she was going to her medical treatments, all of those kinds of things. And there's certain things that can happen that make it worthwhile. But generally, if you are locked up, you will be arraigned via video, so you don't even get to go into the courtroom, via video, early in the morning on the Thursday, or on the week after your grand jury report comes back. If you are out, it's generally a week after, but that Friday instead. If your family member is looking it up on courtclerk.org, it will show the date as if you are out. So be sure that your family is listening to your lawyer and you are listening to your lawyer about any important dates. For the most part, I generally advise people that that arraignment can and should be waived, at least in most situations. Unless there's a reason for it, waive it. You sign what's called a written plea of not guilty, and it also indicates that you are waiving none of your rights, and that is submitted to the court and processed through. It's essentially the exact same piece of paper that will be signed and stamped were you to do it in open court itself. Following that, you are assigned one of the common pleas court judges who will handle your case generally from beginning to end. The first appearance, for lack of a better word, is called the disposition scheduling conference. That's pretty much what it is. At this point in time, your attorney has filed discovery. I'm holding in my hands initial discovery. I've blacked out all of the personally identifiable stuff on it. But your attorney generally at this point in time will have filed what's called a request for bill of particulars. That is a requirement under the law that if requested, the prosecution has to respond with a written narrative of what you did in particular. Hence the fancy legal language, bill of particulars. A demand for discovery. This in itself is 4 pages long and asks for everything humanly possible that we can think of under the rules, and all of us are constantly checking our discovery, following the law to see if there's a case we need to add to this or to work through this. And then a notice of intent to use evidence. That basically ropes the prosecutor in. You have to have They can't hide evidence from you. They have to show it. And generally at the DSC, the prosecutor may not have formal written discovery yet, but oftentimes they'll have lab reports, perhaps what's called 527s, police reports of the incident, and to give you at least an inkling of what kind of evidence they're going to present and go through there. Discovery is a process. But this first hearing really is what it sounds like. It's going to get scheduled for another hearing in about 30 days. During that 30 days, you're going to make a plan with your lawyer. You're going to sit down with your lawyer. You're going to go over everything. Whether you're locked up or whether you're whether you're home, you're going to come to the office, you're going to sit down, and you're going to go over everything. And your lawyer's going to ask you questions. And you need to know that your lawyer is on your side. Again, whether it's a public defender, whether it's a private attorney, someone you've hired, your lawyer is on your side. They are forbidden from telling anyone anything, really. You have privilege. You are protected. And I can't tell anyone, oh well, yeah, he committed a crime. It's my job to defend you. Now, at the same time, at trial, there are certain things I'm limited from. I can't lie. I can't support you lying on the stand. I can't support a witness lying if I know that they're lying. But we make plans, we have conversations, we sort through things to try and figure things out. The next settings in Hamilton County are called plea or trial settings, meaning basically you can be prepared to plea, offer a plea, or set a trial, or have another plea or trial setting, essentially a pretrial. During that time, your attorney may find it appropriate to file various motions, evidentiary issues. I'm not getting this in discovery. I want this video. Where is that? Motions to suppress, meaning evidence was obtained illegally under the Fourth Amendment. I know I've said this a lot today. The Fourth Amendment isn't just a subject for a presentation. It was a solid year of law school. Just that. But all of these things are what's taking place and moving through, and then you go to trial. And the thing about trial is that most cases don't go to trial. And a lot of people get frustrated with that. They want their opportunity to have their day in court. And that's why your relationship with your lawyer is so important. You need to trust them. You need to, they need to be able to communicate with you, because they are going to do everything in their power to mitigate whatever harm may be coming to you. And they may offer, and this is also important to take into account. Sometimes the prosecutor will offer a horrible deal. Just because your lawyer is bringing it to you doesn't mean you have to take it. In fact, I'm required, the ethical rules that I am mandated to follow that allow me to keep my law license say any offer I have to bring to you. At which point, ask questions. Go over it. What does this really mean? What does this mean for my job? What does this mean for my future? Do I have a nursing license that this would impact? Or some kind of financial industry license that this could impact? What happens here? Looking at what is often in felonies, what we're dealing with a lot is drug charges. Fourth and fifth degree felonies, and those are probational offenses. Oftentimes you'll be charged with multiple charges, and they'll be willing to get rid of one or two or several in exchange for a guilty plea to another, for which you go to treatment and you're on probation and it's on your record. But depending on the situation, perhaps it's expungible after all is said and done. You'll be there for a while, but you want to know how it all impacts you, and your lawyer needs to be able to explain that to you. So listen to what they have to say. Trial, good grief, another whole presentation. If trial happens, know that you are going to war. All bets are off. If the prosecutors offered you a deal that suddenly you want to take mid-trial, they might not let you have it. They might say no. We're gonna go all the way through here. Trial can be held in front of a judge. It can be held in front of a jury. That's a strategic decision usually your lawyer makes with your input. And at the end of it, you're found either guilty or not guilty. And if you're going to trial, know that it is a lot of work. It's emotionally wrenching. It is tiring. It is exhausting. It is all-encompassing. So be ready for it. Okay. This is usually a part where I'd say, are there any questions? I'm trying to think if there are any. Feel free to email me. My email's on the on the presentation header and footer. All right, now let's say misdemeanor charges are what's actually in play here. You don't need a second arraignment. You've been charged with a misdemeanor. Charged with a misdemeanor. Oftentimes it is set for trial right away in front of a judge. There's a couple of reasons for that. One of it is just as a practical matter, that is the best way to get all the witnesses and everyone involved in the case in one room to perhaps try and hammer out a deal or to figure it out. Or it can be set for various pretrial levels to go through to make sure all discovery is gotten, all that kind of things. The thing about a misdemeanor is while there's a lot at stake, particularly if it's a serious misdemeanor, there's less information involved. There's less questions of big sizes. The municipal court here in Cincinnati handles the entire county, and it is one of the highest volume courts in the state. Just a side note, so you'll understand it. When you're going through municipal court, it's slammed. There's just people in the hallway. There's not enough room to sit. But the court is a recent study came out of Cleveland. The Cleveland Plain Dealer did it because Cleveland's municipal court is scattered, and the thrust of this report that was reported in the Cleveland Plain Dealer was that Cleveland should look at how Cincinnati does it because it's all centralized. There's one probation department, there's one central court office, there's one clerk, so it allows everything to move a bit more efficiently, despite the fact that when you're in there it looks like chaos. So just follow your lawyer and trust them that they've been there before and will walk you through it. Just like in a felony, you make a plan with your lawyer. They've filed discovery, the same things. They've got a packet of information that has come back, and I'd show that here, but I risk violating some privacy or anything like that. Sometimes discovery is this high. Sometimes it's just a handful of pages. It all depends. But it lists the names of who's involved, the witnesses, all of these things that allows you to tell your lawyer, oh, well, Joe was there, but Joe will tell you what happened. And then your lawyer will go talk to Joe and see what Joe's actually going to say. And maybe Joe's helpful, or maybe Joe's not. And you figure all that. You make a plan with your lawyer, and then again, trial. Again, could be a bench, or could be to a jury. Again, most cases don't go to trial. But if you want a trial, every lawyer I know will go to the wall for you. That's our job. We will also warn you that you have to look at the plea as to a risk-benefit analysis. Is the risk of going to trial, and in the case of a misdemeanor, potentially facing 180 days in jail, worth taking? Is that risk worth it to you? Oh, went through that already. Sorry about that. Most cases don't go to trial, jury or bench trial. Talked about motions. And that's basically where we are. So, as we review, make sure that you're talking to your lawyer. Know that somebody is going to be there to stand up for you in room A, in that very first arraignment when you're confused and scared and have been spent all night probably sitting on a concrete bench, maybe sleeping next to a whole bunch of strangers in the same situation you're in. That we're going to take care of you, we're going to get you through the process, and we're going to walk you through it. But that is basically how it works in Hamilton County. I've left out a lot of the details in an effort to try and cover everything from beginning to end. But know that each and every one of the criminal defense attorneys here in Hamilton County wants the best outcome for their clients, and they will work hard to get it. So thank you.